Hi everybody, good afternoon. Thank you very much for joining us for this webinar on Abbey and Simply, the Supreme Court's decision. I'm just going to hand over to my fellow panelists to introduce themselves quickly. With me is Patrick Hennessey.
Hi everyone, I'm Patrick Hennessey. I'm a 2010 Cool barrister at Essex Chambers, specialising in construction disputes, both domestic and international. I'm looking forward to sharing some thoughts with you today.
Joining us remotely is Vivek Kapoor.
Hello everyone, thanks for joining us. I'm Vivek Kapoor. I'm a barrister and arbitrator, and my practice spreads across the infrastructure, construction, energy, natural resources, and banking and finance. And I'm looking forward to discussing a very interesting topic with my brilliant colleagues today.
Finally, I'm David Hopkins. I am 2013 Cool. I practice mainly in construction, commercial, and regulatory law, both domestic and internationally. Please do ask any questions you've got using the Q&A function, and we will try to address those we can towards the end of the webinar. We're going to start today, but I'm going to take you through the background and the Supreme Court's decision. And then Vivek is going to talk about implications for beneficiaries and donors. And then we're going to have a discussion. Patrick's going to raise some points around the wider implications for the construction industry, and we'll speak to that. But to start on the background and the reasons that the Supreme Court has now allowed the appeal, apologies, seem to be having some issue with sharing the slides, so I'm just going to start, and if we can get the slides up, then we will. First of all, the basics. Construction contract within the meaning of the 1996 Act. You'll all be familiar with Section 104, which provides that in this part, a construction contract means an agreement with a person for the carrying out of construction operations. Now, emphasize the word for in that definition. You'll see why as we go through what's happened recently with the Supreme Court's decision. Then on to collateral warranties. As you know, or as those in the audience will be aware, collateral warranties are very popular in the construction industry. Typical scenarios will be that of a purchaser of the building after practical completion who wasn't the employee during the build. Someone like that may well wish to take a benefit of a collateral warranty from a contractor, and they'll do so because of the difficulties with third-party pure economic loss claims following Murphy and Brentwood. The collateral warranty gives them the contractual right, of course, to sue directly the person who they say is responsible for any defects. You might also see a landlord who employed a main contractor in a D&B type scenario taking collateral warranties from one of the main contractor's sub-consultants, such as the architect. A warranty is simply a promise, and in the present context, it's a promise that the construction professional has done their job properly. Often, of course, they also promise to continue to do so, but that job, which they are making promises about, is one they're obliged to do under a different contract to the collateral warranty. So, in Abbey and Simply, Simply Construct, the defendant, was engaged by Sapphire Building Services to build a care home. And the works commenced in May to June 2015, and practical completion was achieved in October 2016. As may well be familiar to those in the audience, the contract under which Simply was engaged to build the care home included within it obligations to provide on-demand collateral warranties to certain third parties. Here, those third parties were Topan, the first claimant, and Abbey Healthcare, the second claimant. Now, Simply did provide a warranty in favour of Topan in October 2015, whilst the works were still ongoing, but it didn't do so in favour of Abbey. Top Ann later purchased the freehold, and Sapphire novated all of its rights and obligations under the building contract to Top Ann. Shortly thereafter, Top Ann entered into a 21-year lease with Abbey. And as with so many buildings which were built prior to the Grenfell Tower fire, unfortunately, fire safety defects were later discovered in August 2018. So Top Ann, the landlord, engaged third parties to carry out some remedial works. Now, this collateral warranty, as I say, hadn't been executed in favour of Abbey, and indeed Top Ann was forced to bring proceedings for specific performance. Once it did bring those proceedings, I think the contractor could see which way the wind was blowing and did indeed execute a warranty in favour. You might be wondering why otherwise it decided to do so only after the defects had been discovered. It was contractually obliged to do so, and essentially Top Ann forced it into doing it. But note, the collateral warranty was only executed in favour of Abbey sometime around 4 years after the works had been finished. Notwithstanding that the warranty was only executed in favour of Abbey 4 years after the works were complete, the warranty was in these familiar terms. The contractor has performed and will continue to perform diligently its obligations. It has exercised and will continue to exercise all reasonable skill and care. And indeed, that was so for both the carrying out and completion of the works and the design. Of course, PC having been achieved several years prior, it's probably the case that actually simply wasn't going to do very much more of this whatsoever. But, of course, that's not a bar by itself to parties making an agreement in these terms. Disputes, of course, arose between the parties as to Simply's liability for the defects and the costs of carrying out and completing the remedial works. Simply didn't agree to those adjudications being, both Abbey's and Top Ann's disputes being referred to a single adjudication. So both Top Ann and Abbey then made separate referrals, albeit that the same adjudicator was appointed for both adjudications. Simply challenged jurisdiction in respect of Abbey's adjudication. That challenge was rejected, and in time, the adjudicator, Mr. Binden, awarded around £1 million to Top Ann and £870,000 to Abbey. Simply didn't pay the adjudication awards, and Top Ann and Abbey both commenced enforcement proceedings, which were heard together by Mr. Martin Beaudry, QC. Top Ann's enforcement claim was granted, nothing further arises on that, it wasn't the subject of any appeal. But Mr. Beaudry refused enforcement to Abbey. He held that the Abbey collateral warranty wasn't a construction contract, and he held that that was because by the time the collateral warranty was executed, it was a warranty of the state of affairs in the past, rather than a promise about things in the future. And he said it was akin to a manufacturer's product warranty. Abbey appealed to the Court of Appeal, and the majority Lords Justices Coulson and Peter Jackson allowed the appeal. Lord Justice Coulson, who authored the lead judgment, held that the Abbey collateral warranty was a construction contract. He said, first of all, a collateral warranty can in principle be a construction contract, and it will always depend on its terms. He said, as Abbey's collateral warranty did not make a warranty only to fixed or past state of affairs and was promising a future performance, that is, will continue to perform, it could be deemed a construction contract. Lord Justice Coulson, in his reasoning, placed some reliance on the decision of Mr. Justice Aikenhead in Parkwood. That decision was handed down in 2013, and that was the only previous authority on the issue of whether a collateral warranty is a construction contract. Mr. Justice Aikenhead took a very similar approach to that which Lord Justice Coulson adopted in Abbey and Simply, and it was all to do with whether or not the warranty made promises of future performance. Coulson, Lord Justice Coulson also said that the time the warranty was entered into, here specifically the fact that it was entered into after practical completion, 4 years after, didn't matter. What mattered was the terms of the contract and the bargain that had been struck between the parties. In so construing the contract, it should be noted as well that Lord Justice Coulson expressly adopted a broad interpretation of Section 104. Lord Justice Stuart Smith dissented. He said the warranty was merely a promise in relation to Simply's obligations to a third party under the building contract, and there was nothing in its terms which suggested that Simply was undertaking direct works for Abbey. Now that perhaps is essentially an arguable point. It certainly is the case that a collateral warranty will always, or rather a usual collateral warranty will always be the case that the promise is being made to a third party about the donor of that warranty's obligations under a separate contract. But the reason Lord Justice Stuart Smith said this was crucial was because of that word again, for. Section 104 of the 1996 Act requiring that the agreement be for the carrying out of construction operations. In his view, that was determinative. You'll see on the slide as well, an example he gave was that an injunction would not normally lie to enforce the underlying obligation. If one is the beneficiary of a collateral warranty, one cannot use that warranty to found a claim for specific performance of the building contract. So that was the dissent. And in the Supreme Court simply submitted that Lord Justice Stuart Smith had reached the right decision for the right reasons, and that essentially his dissenting judgment should be adopted. Simply also criticised Lord Justice Coulson's broad statutory interpretation of Section 104, saying in effect that his broad and purposive approach led him erroneously to treat the word for as meaning in respect of. That was something which the Supreme Court agreed with. Lord Hamblin authored the judgment allowing the appeal with all of the other lords and lady judges agreeing. Emphasise again the word for, and in addition to the points made on the slide as to why it's difficult to see how the object of a collateral warranty is the carrying out of construction operations and so on, there's also the point made at paragraph 66. Whether or not, said Lord Hamblin, whether or not the carrying out of construction operations has to be the main object of the agreement, it must surely be necessary for the agreement to give rise to the carrying out of such operations. A collateral warranty that merely promises to the beneficiary that construction operations undertaken under the building contract will be performed does not do so. That applied to the warranty of which Abbey was a beneficiary, and so the appeal was allowed. Now, the Supreme Court recognised its approach is likely to mean most collateral warranties will not be construction contracts. But it said that there are good reasons for so concluding, and for concluding that in general, such warranties were not intended to fall within scope of the 1996 Act. The Supreme Court noted, for example, that payment obligations imposed by the Act aren't applicable to collateral warranties. One of the twin purposes of the Act was the improvement of cash flow, and that, the Supreme Court said, is not furthered by applying the Act to collateral warranties. The beneficiary of a collateral warranty has no payment obligations itself unless it has and chooses to exercise step-in rights. The court also considered it would be beneficial for certainty that collateral warranties are generally outside the Act, rather than parties and their advisors having to carefully consider the precise wording of a warranty in each and every case. Indeed, those difficulties were apparent from the fact that 2 judges during these proceedings had considered the warranty to be a construction contract, whilst 2 hadn't. And of course, they've given extensive reasons in both cases, in all 4 cases, I should say, as to why they reached those particular opinions. Finally, the Supreme Court said that Parkwood couldn't be distinguished on the facts from Abbey's collateral warranty, or rather the facts of that case couldn't be distinguished from the facts of Abbey's case. And therefore, in effect, Parkwood is overruled and is no longer good law and should not be followed. In summary then, the Supreme Court's reasoning was that for an agreement to be within Section 104, it must be an agreement which gives rise itself to an obligation to carry out construction operations. The collateral warranty in this case, as is usually the case, did not do so, and therefore it is not a construction contract, does not fall within Section 104, and therefore the adjudication provisions do not apply. And Mr. Vinden's original decision, therefore, was made outside of jurisdiction. Going to hand over to Vivek now to talk about the implications for beneficiaries and donors of collateral warranties.
Thank you, David, for that very impressive summary of the case. The timing of this case, I think, gives us a very interesting context of into the importance of what the Supreme Court says. Now, in England, in United Kingdom, we have a new government which is talking about planning changes. It's talking about new energy projects. It's talking about large social infrastructure. Now, there is clearly a policy agenda to fight NIMBYism, as it's been called, and not in my backyard. Now, when there is going to be such a massive push for infrastructure, it's not going to be only funded by the government. It has to be funded by private finance, and some of this private finance is going to be foreign finance. Now, why is this important? Is in a simple construction contract, for example, you're building your house, you're redoing your house. It's a contract between the employer and the contractor. But in an infrastructure project, there are many actors that are involved. There are a wide range of parties that have an interest. So the most important being the funders, but then you have the purchasers. If it's a residential property or a commercial property that's going to be used by tenants, then the tenants. Then there are other parties involved as well. Now, some of these parties don't have a direct contractual relationship. If you don't have a direct contractual relationship, then the chances are, if you need to make a claim for defects, you need to go into the zone of common law negligence. Now, collateral warranties essentially are the bridge that allow for these defects. And that is what Lord Hamlin emphasized when he said the main object or the purpose of such a warranty is to afford a right of action in respect of defects carried out in the construction work, not the carrying out of such work. Now, what this essentially does is it draws a very clear dividing line, as Lord Hamlin again made a reference to that at para 78. Lord Hamlin recognized that the new dividing line would be in the interest of certainty. Now, what the beneficiaries in a large infrastructure construction project want are certainty. Now, the finance aspect is not very keen to be slotted into adjudication. They're often not ready justice of adjudication, but equally what they appreciate is certainty, and what this decision is giving is precisely that the majority of contracts will not be falling under the Act, which means they won't be subject to mandatory adjudication. From a drafting perspective, what it also means is now if a party wants to have the benefit of an adjudication, it should specifically provide that. And if it's not provided, then it is not going to automatically fall into that. I think in the overall context for beneficiaries, this is a very important decision and is likely to give them the much needed clarity that wasn't there. I'll let my colleague talk about the wider industry, and then we'll get back to discussing some of the more interesting points that come out.
Yeah, thanks very much, and thanks, David, as well for that introduction. These couple of slides are headed implications for the construction industry. I think it's probably right to say implications for construction and construction law industry, because I think these apply equally to us as construction lawyers as they will do to contractors or employers. And clearly there are implications here. I think we can broadly look at those in sort of two aspects. There are direct implications, and I'll talk briefly about those, and then there are some sort of potentially more theoretical, philosophical implications about what this means for the direction of travel. Vivek's already touched upon it. I mean, the clear, concrete implication, it comes out from, I think it's mentioned as paragraph 78 of the Supreme Court judgment, that there is now, and it's expressly said to be an interest of certainty, a dividing line, meaning that collateral warranty is going to be generally outside the 1996 Act. And this is effectively reverting to the position as it was generally understood to be before the 2013 decision in Parkwood. And it's quite interesting, I think, to note some of the commentary around effectively overruling Parkwood, because the Supreme Court went to the length of noticing that they're paying due respect to the decision of Mr. Justice Aikenhead, experienced TCC judge. This was greeted, Parkwood was greeted with dismay by some commentators. That's noted in paragraph 82. And actually, the general reaction in the industry was adverse, I think it would be fair to say. So to the extent that we return to that pre-2013 position, and a position which I think broadly lots of those inside the construction industry would say makes more sense, that's quite a positive implication. It gives some certainty. But what does that mean for parties who want to adjudicate disputes under a collateral warranty? Well, they can still agree to do so. There's no prohibition on that. You could put an express provision in a collateral warranty providing for disputes to be referred to adjudication. And in the alternative, you could draft the provisions of the collateral warranty such that there is a distinct and separate obligation, construction obligation to the beneficiary. That presumably had to involve an element of supervision or direction of regulation of carrying out the construction works in line with Mr. Justice Hamden, with Lord Justice Hamden's judgment. But there are mechanisms with which that can be done. And I think where this both touches on practical questions that lots of us might have now, particularly with existing disputes, and then also blends into the more sort of theoretical, philosophical debate, is what now happens with existing disputes, because there will be countless examples of parties in a similar position to those who are in the Supreme Court, where we have probably fire defects post-Grenfell. There will be parties expecting to adjudicate those disputes under a collateral warranty under the previous position. And I think David will agree. I think he's got an example of this that he's currently involved in himself. Are these disputes now going to have to go to court? What are the benefits of that? What are the disadvantages of that? I think you can look at these in two ways. You can say that it's potentially problematic or inefficient, that a whole bunch of disputes now have to go on a separate track. A positive way to look at this might be to say that actually one of the slight disadvantages with adjudication in some respects is that it's a private decision that doesn't have any wider application. It may be now that a suitably broad test case involving fire defects that results in a reasoned decision from the TCC or possibly higher, but gets to a point where it's effectively accepted and established. Disputes may not have to be referred to adjudication. They may be able to be settled in line with that principle. So we might end up getting authority on points that have previously remained undecided because they've always been determined by adjudication in the first instance and then not dealt with any further. So I think that's the practical side. Philosophically, I think it's a brief judgment. It's a well-reasoned judgment. It's only 26 pages. It does bear reading if people have the time. And this is very much a personal view, but I think it can be taken as signalling a slight retreat from an all-inclusive, all-encompassing approach to Section 104 of the 1996 Act, and to try to get all peripherally related construction disputes within the mandatory adjudication provisions. I think it's interesting to note, and I'll just flag up a couple of references for those who want to have a look through. The summary of Simply's submissions at paragraph 57 of the Supreme Court judgment, where they summarise these Day King's Counsel submissions that Lord Justice Coulson had urged in considering a broad approach to interpretation should be adopted. That's 1.3. To conclude that the statutory purpose of the 1996 Act was the same factual disputes about the carrying out of the same construction operations can be dealt with by the same adjudicator, even where there are two different contracts. And then 4, the broad and purposive approach, which led him to erroneously treat the word for as meaning in respect of. Now, in typically polite judicial language, noting Lord Justice Coulson's considerable experience and expertise in this area, the Supreme Court then went on to find that there was some force in those criticisms. And there are a number of references. David highlighted the reference back to the cash flow, one of the twin purposes of the 1996 Act at first. Is payment, is a cash flow assisted by having collateral warranty disputes adjudicated compulsorily? No, not particularly, not in this instance. And there are just a couple of references. There's one in paragraph 78 to the fact that you will still have a right to adjudication, but it will be voluntary rather than mandatory. And then again at paragraph 83, allowing the parties to contract into the adjudication regime where it's desirable, but not to be fixed with an inability to contract out. And I just wonder whether one of the takeaways from this in the broader terms, the Supreme Court signalling that the mandatory adjudication should not be all-encompassing, and that obviously parties can expressly elect to have their disputes resolved in that way, but the very broad approach, an approach which I think sort of slightly becomes synonymous with Lord Justice Coulson, perhaps we need to sort of go back to the limits that the 1996 Act does place on adjudication as a dispute resolution mechanism. But I'm sure there'll be, I think I've already seen a couple of questions on that, I'm sure there'll be others, so let's open that up to discussion, shall we?
Just picking up on a point you raised, Patrick, and it may or may not address people's questions sufficiently. Talking about the fact that you could include express provision of a right to adjudicate in a collateral warranty. Now, thinking about the kinds of terms we often see in the industry, and indeed specifically did see in Abbey and Simply, where a building contract may well require the contractor to enter into collateral warranties on demand. Those will normally then be set out in a schedule to the building contract, and the terms, therefore, of the collateral warranty effectively are pre-agreed. It may well be the case, especially looking at this from an employer's perspective, that you start including within those schedules, Schedule 5 that no one ever reads until they're told that they have to execute the collateral warranty. You start popping them in as standard boilerplate. Do you think that's a possibility?
I think that's a possibility. I think that's the advisable course of action. I think that, as we all have experience of, probably what's more likely to happen is people will forget to do that, and we'll see a space of jurisdiction challenges on adjudicators nominated to determine disputes under this. But yeah, I mean, I think I think looking back at this distinction that has been drawn, this for the sake of certainty, as the Supreme Court said, that is clearly an aeroplane with a banner being flown above it for construction lawyers to say, look, let's have a think about this. The position wasn't satisfactory after Parkwood, but we've bimbled along for 11 years now. Let's get some barriers involved.
And ultimately, it will be a case of who's got the greater economic power, really. The Supreme Court's given a route to continue to be able to use adjudication in collateral warranties if you want to. The if you want to being perhaps slightly circumscribed about who gets to pick and choose the terms.
Yeah, and I think, and they're very careful not to give any sort of adverse commentary on the suitability of adjudication to determine these disputes, because I think we all have experience where actually both parties will want this to be dealt with quickly and efficiently and in all the kind of positive ways that adjudication can. So I don't think I should stress that my kind of theory that maybe it's sort of setting a high watermark should not be read as it being critical of that approach. It's simply saying that the 1996 Act did provide limits on mandatory adjudication, and that those limits should sort of not be expanded or kind of be seen to kind of be pushed back almost sort of by osmosis. Let's keep to them. But actually, this is a very mature dispute resolution process now, and most parties will know what the benefits and disbenefits are, and they are free to work within those.
I think the Supreme Court, what I found very interesting is the Supreme Court, without directly emphasizing it, emphasizes a principle, a sort of fundamental principle of English contract law, that ultimately the party's contract is paramount. Now, Lord Hampden recognizes that nothing stops the parties to go to the rough and ready justice of adjudication in collateral warranties if they want it, but that should not be the presumption. That should not be the sort of starting position. If the parties want it, by all means, they can revert to it. And I think I agree with Patrick. There is a policy indication that adjudication is meant for some things, but it should not be seen as overarching and everything needs to be slotted into mandatory adjudication. It is the party's choice, and the parties should obviously consider that very carefully before exercising that choice. And it should not be that the statute is read in a way that parties need to necessarily go to adjudication.
I think what will also be interesting to see is whether, because I assume there will be out there somewhere, a factual matrix and a collateral warranty and a construction contract, the terms of which fall much more closely towards the providing for a distinct, separate benefit of carrying out construction obligations, and one can foresee that being argued up to the point where the court says, well, okay, Abbey simply says generally collateral warranties won't be a construction contract, but of course you can't lay down a hard and fast immutable rule precisely because of the parties' freedom to contract in their own terms. So there clearly will out there be collateral warranties that still fall within this definition, and I suspect we'll start to see some disputes over those as well.
Yes, I suppose the bit of advice, or rather the sort of warning, which always rings through my head, is never to apply a label too literally. And what would be a mistake, of course, would be for people to go away essentially thinking, oh, Abbey simply has said that collateral warranties aren't construction contracts. Indeed, you can imagine there may well be some weird bespoke warranty that's been negotiated, which says in the event that the beneficiary serves notice, then it will be able to direct the contractor to carry out certain remedial works or whatever it may be. And that, obviously, that's purely a hypothetical scenario, but that may well then be a construction contract. So, as always, labels are never determinative, yes. And Abbey simply certainly wouldn't be saying that. Sorry, Vivek.
If I might just add a quick one to that, some of the contractual warranties have step-in options that get exercised, and that is, I think, one of those examples that my colleagues are talking about, where you will need to be very careful of where it ultimately lands, and it's not going to be what you might think is the sort of broad position under the Supreme Court judgment.
Now, Vivek, you mentioned about the fact that the Supreme Court was emphasising the parties' freedom of contract and ability to decide on terms to which they agreed. We've had a question in, under the Texas adjudication rules, the adjudicator can decide their own jurisdiction, which is to be binding. Would this make any difference to this case if each side agreed to the Texas rules?
No, I don't think so. I think the jurisdiction of an adjudicator, very much like that of an arbitrator, is ultimately defined by the contract of the parties. So if the parties haven't contracted for that, it is not for an adjudicator to step beyond the jurisdiction that has been given to him or her, or to a panel, and then try and fill the gaps of the parties' contract.
Yeah, I think the only slight gloss I'd put on that personally would be, if, of course, the parties wish to confer jurisdiction upon an adjudicator, they could agree a short deed of variation or something like that to their agreement. If you've got a scenario where people want to give an adjudicated jurisdiction, there's nothing in Abbey and simply stopping you doing that. I completely agree with you, Vivek, of course, that it won't be the case that simply because the text of rules allow the adjudicator to make a decision that will automatically become binding. But if the parties do wish to confer jurisdiction on an adjudicator, then they can. So if you've already got as far as saying we agree we want an adjudicator to decide our dispute, that will be fine. You can still go and do that. But I would personally, I think generally speaking, I would prefer to be in a position of advising a party if, in effect, in substance, you've already agreed this. Why don't we make it completely rock solid and just agree a short deed of variation which says we agree that there's adjudication rights under this contract, rather than trying to sort of wade through following Abbey and simply using the fact that you can make reference to the text of rules and so on. We've also got a couple of questions on third-party rights. Now, this is one that I think people have raised in the past, possibly all the way back when Parkwood was first decided, and essentially question being, under the Contracts Rights of Third Parties Act 1999, would it be possible for a third party such as a building owner who wasn't party to the original JCT main contract, whatever, exercise the adjudication rights inherent in that contract? Now, my instinct, my gut feel is no. I don't know.
I see that. I see that. I think to do so would be sort of inconsistent with the limitations that are being imposed. But you're right. It's one of those ones that takes a bit more sort of thinking through to why you get that gut instinct. I think there's an interest. I think concern on that question, and also on the sort of question of step-in rights. Don't they indicate that this is actually a construction contract? I think both of those questions are addressed slightly, or not addressed, but they're looked at. Again, it's a paragraph 63 of the Supreme Court judgment, and it's actually quite an interesting discussion in more general terms of contractual and statutory interpretation, because it's where they talk about the natural ordinary meaning of the word for, and whether Lord Justice Coulson adopted an overly broad approach to for the carrying out of construction operations. Now, people will be able to read that for themselves, but the Supreme Court alighted on Lord Justice Peter Jackson's statement that the word for requires that the purpose or the object of the original agreement must be the carrying out of construction operations. Now, it's not done expressly, but it seems to me that the Supreme Court is drawing a distinction almost between the primary purpose or object of an agreement, which they're saying in the case of the collateral warranty is not for the carrying out of construction operations, and a sort of ancillary purpose that the step-in rights would suggest, and it would also then have those kind of knock-on consequences where the third-party rights can be exercised. But that's a really sort of interesting and sort of meaty topic. Have we been given overly broad applications of for as meaning in respect of, when actually what it means is for the purpose of?
This is, in some ways, it's a real lawyer's decision in a sense. But I mean, my general view of what the Supreme Court has done is that it feels right, and I know that's not a particularly sort of analytical way of looking at it, but when you read the plain words, an agreement for the carrying out of construction operations, and you just think about them, trying to imagine it without any pre-existing ideas, and the fact we've all got used to adjudication being the preferred dispute resolution mechanism. When you just think about the words, an agreement for the carrying out of construction operations, a collateral warranty doesn't really smell or walk like that. It's not got the same. So yeah, the word for turns out to be incredibly important. I can see we're still getting some questions in. Most recent one, and I'm going to this is the danger, if you read out the most recent one, it might be the trickiest. Most funders have the right to get an assignment of the building contract and or appointments, etc., as part of any funding. Would this not avoid the problem? And most purchases of completed developments demand assignment of these too. Now, I think an assignment certainly would be sufficient, and certainly a novation would be sufficient. I'd say novation without any question of a doubt, because in effect, then you have a new building contract come into existence between the funder and the main contractor. Now, an assignment of the rights, I don't see any particular reason why an assignment could not happen simply of the right to refer disputes to adjudication following practical completion. I don't see in principle any reason why the employer should not be able to assign those rights, possibly on payment of a fee, to a funder. So the short answer to that question is yes, effectively that does avoid the problem. If you, as the person who wishes to bring the adjudication proceedings, is now in effect the party to the original building contract, then there shouldn't be any problem. Whether or not, of course, that's a popular way of doing this now remains to be seen. That's purely for people to take on commercial decisions. People may start charging more for them, for example, for those assignments.
If I may, the way some of these assignments tend to be worded, when it comes to tenants or purchasers, is it is essentially a collateral warranty. It never puts you as a direct party to the contract. So if again, I think the point David made, if you think you're advising a party, or you are a party that is in a position where you would want to rely on adjudication, try and have it directly contracted in rather than this route, because there is a good chance that the other party might block it using the judgment.
And worth raising that actually, now, no one obviously wants to end up in a dispute, and someone who you are essentially saying to, you're likely to be my defendant, isn't likely to want to agree things with you, generally speaking. But it probably is in even a prospective defendant's interest to agree to adjudication if it's not otherwise available, given that if you're going to launch a claim for, let's say, £2 million in the TCC, we all know how much that will cost and how long it will take. And if the defendant to that action thinks they're likely to be paying something, even if not the whole 2 million or whatever, they might as well agree to adjudication to get the costs down and keep things relatively quick, efficient, and so on. So there's no harm in proposing to a prospective defendant that you think, for reasons of efficiency and costs, why don't we just all agree to adjudication, even though we know at the moment the collateral warranty won't allow us to do that. Well, I think that's probably a good time to wrap up for now, unless, just to check, there's no further questions that we've had in. Unless, of course, sorry, Patrick or Vivek, you had anything further. What I think we have asked you to do, if you haven't had a chance to put your question in, is please do follow up. Please do email in your questions. Thank you very much for joining us. And I hope you have a good rest of the day.
Thank you.